Okay. So that's where you can find the Chula Vista TPO. Um, so let's go kind of right into it. Real brief overview. The Tenant Protection Act, the TPA, is the statewide. The TPO is local. All right. The TPA, it covers rent cap and it covers just cause termination. The TPO only covers just cause termination. It has no impact on the rent caps in the TPA. They're a little bit similar. They're a little bit different. I was going to do a Venn diagram, but then it got really complicated. So maybe in future episodes, I'll do that. In the Tenant Protection Act, single family homes and multifamily home properties less than 15 years old can be exempted. In the Tenant Protection Ordinance, only single family homes that are not corporate owned can be exempted, meaning all multifamily is included, is affected by the TPO. And another weird caveat, duplexes and homes with ADUs and or junior ADUs can be exempted if the owner resides in one of the units for the duration, the entire duration of the tenancies of the other units. So that probably doesn't apply to a lot of people, but that's in there. Same thing with rooms. If you know somebody that's renting rooms, if they are living in the property and are renting out up to 2 rooms, then they can be exempted. Or if they share bathroom or kitchen facilities, they can be exempted. Otherwise, they can't. But for the most part, I think most people are looking at this from a single family home or multifamily property point of view. And so just as a reminder, the TPO and the TPA, by default, they apply to all properties. Every single property is it applies to. However, both ordinances can be exempted, but they're only exempted when the landlord claims the exemption. And to claim the exemption, you have to have specific verbiage in the lease contract. Otherwise, by default, the property is affected by either the TPA and or the TPO, depending on the situation. So it's important. Last month, we had to mail out a lot of notices to tenants saying, hey, your property is not affected by the TPO. It's exempted. However, or at the same time, nothing changes. So I had a couple of people contact me kind of in panic mode. What does this mean? And I had to just tell them, hey, it just means everything is the same as normal. Nothing changes, but we have to send this out because it's law now. So the TPO and the TPA by default apply to all properties unless the exemption is claimed. If you have any questions about whether your property is exemptable or able to be exempted, I don't know the right wording on that, reach out to me. I'm happy to try to help you out. The other thing to remember, the TPO, the Chula Vista Ordinance, does not change any rent cap laws in place. It's simply for no-fault terminations and highlights landlord responsibilities to the tenant and the city for those things. All right. And while we're going through this, if you do happen to have any questions, go ahead and put that in the Q&A or in the chat. But I'll probably, the Q&A would be the best preference. So what I'm going to do is I'm going to pull up the Chula Vista TPO, and we're going to kind of go through it a little bit here as well, so that way you can you can see what we're talking about. I'm going to highlight a few things, and I don't want to go over and totally bore everybody to death because it can be really cumbersome. But we're going to go ahead and share this, and let's see, there we go. Okay. So here you are, the Residential Tenant Protection Ordinance for City of Chula Vista. I'm going to scroll through this, and I may highlight a couple of things here and there. I first want to go over some of the definitions. So disabled, this is going to be important, disabled and elderly, because that's going to affect things later. Disabled, it defined by California Government Section Code. If you want to look that up, you can. Elderly is anybody 62 years or older. So if you have any of people in that category in your properties, and your property is not exempted from the TPO, then that will impact you. Another interesting thing that we'll need to remember, a family member refers to the spouse, domestic partner, children, grandchildren, parents, or grandparents of the unit owner. So basically the person, their spouse or domestic partner, plus or minus 2 generations. That also includes adopted children as well. Substantial remodel is a very important one because that's one of the reasons for being able to terminate the lease. A substantial remodel has to include all 4 of these criteria. It's got to be structural, electrical, plumbing, or mechanical system being replaced or substantially modified. The cost, excluding insurance proceeds, land costs, all that stuff, has to be equal to or greater than $40 per square foot of the entire unit. So if you have a 500 square foot unit that you're remodeling and you want to move somebody out, the cost of that has to be greater than 500 times 40, greater than $20,000. Okay. You also, number 3, need a permit. You would have to be able to have a permit required from a governmental agency in order to do that. That also includes abatement of hazardous materials, lead-based paint, mold, asbestos, etc. And then 4th, it's necessary for the unit to be vacant more than 60 days in order to complete the improvements. So they're trying to get away from cosmetic. If it's a cosmetic repair, new countertops, new carpet, new paint, that's not a substantial remodel. A substantial remodel would be, we're replacing plumbing, we're replacing electrical, we're doing multiple things all at once. It's going to require, maybe moving walls, reconfiguring things. It's not just a simple cosmetic thing. A couple of other things to understand. Did I skip that one? I did. Okay. So residential rental complex, 1 or more buildings located on a single lot, basically something with 3 or more units owned by the same owner. Okay. 3 or more units, basically your multifamily. And then residential rental unit is going to be basically any residence that is being rented out. Okay. Kind of self-explanatory, but some of those nuances do play into effect a little bit later. All right. So I wanted to go over some of the exemptions. My agenda here. All right. So we're going to go over some of the exemptions. The first one, single family owner occupied residences. Again, this goes to if there's a ADU or junior ADU. If the owner resides in one of them and is renting out, an ADU, or lives in the ADU, is renting out the house, they can be exempted. B, property containing 2 separate dwelling units within a single structure, like a duplex, as long as the owner resides in one of them. C is going to be the most common one here, and that is going to be a residential rental unit that is alienable, separate from the title to any other dwelling unit. That's a fancy way of saying it has its own assessor parcel number. So every property has its own APN. It's like a fingerprint to people or a phone number for people. Everyone's got its own specific one. And if you look up in the tax records on what your APN is, you'll see it's like a 9-digit number. Okay, and it's specific to each individual property. For a single family home, there are no APNs that are the same. If it's a multifamily, you may have 2 or 3 or 4 or 100 units occupying the same APN. So when they're talking about on item C here, your homes, your condos, anything that's owned separately from other units can be exempted as long as it's not a real estate investment trust. And that is a very specific entity. I don't believe any of my clients even have, are involved in the REITs, the real estate investment trust. It's very different. It's much different than if your property is in a regular trust, like a living trust, or revocable or non-revocable trust. Those are different. So you can have it in a REIT. It cannot be owned by a corporation, or if it's in an LLC, which is fine. At least one member. You can't have any corporations as members in the LLC. And then, of course, management of a mobile home park. They have their own rules. So for most properties, single family homes, condos, those can all be exempted from the Chula Vista TPO. However, and this goes into the, it has to have this highlighted section word for word. And again, it's on the Chula Vista website on the TPO. It will have it on there. You have to have this specific verbiage in there, that the property is not subject to the rent limits imposed by 1947-12. That's the state law that covers rent cap. Most leases, and all the leases that I do, will have a wording in there that exempts the property, if it's exemptable, will exempt it from the statewide Tenant Protection Act. This supersedes that. Since the ordinance supersedes the TPA, they have to have this verbiage in there. So even though it talks about rent limits, the TPO itself does not touch the rent limit stuff. However, and is not subject to just cause requirements of Section 1946-2. That also is talking about the statewide Tenant Protection Act. And then Civil Code in Chapter 965 of the Chula Vista Municipal Code. So it's exempted from that. So that's the fancy way of saying the property is exempted from all of this. And you're confirming that it's not a REIT, that it's not owned by a corporation or an LLC in which at least one member is a corporation. So we're going to scroll down a little bit. The other kind of exemption thing that is not real common, but if you're renting, if you have a house and you're renting rooms out, if you share a bathroom or kitchen facilities with the other people, then you can also be exempted if you're renting out more than two rooms. So just remember that in case that goes applies to you. Harassment and retaliation. Don't do it, please. It gets really bad. It gets really messy. There's a lot of penalties involved, and it gets very expensive very quick. So if you have any questions as to what you can or cannot do to a tenant that's causing you problems, probably don't do it, or consult an attorney first. This goes into detail about all the different ways that people, are being harassed. And unfortunately, this happened to some tenants and should not have by state law, and should not just by any laws of ethics. So you can't interrupt, terminate, or fail to provide housing services required. You can't fail to perform repairs or maintenance. You can't fail to exercise commercially reasonable efforts and diligence to complete repairs. You can't abuse the owner's right to lawfully access the property. You can't go in there every day, okay? You can't affect their right to their quiet enjoyment. You can't abuse the tenant with words which are offensive and inherently likely to provoke an immediate violent reaction, okay? You can't influence or attempt to influence a tenant to vacate. You can't threaten the tenant by word or gesture with physical harm. I think that was worded wrong. I think they meant threaten the tenant with physical harm by word or gesture, but we know what that means. So any of these things, don't do it. It will negate any chance you have of getting your tenant out of the property. So just cause, we're going to talk a little bit about this. Just cause, again, that is simply saying that you have a legitimate reason to terminate a lease. And remember, there's two different caveats to that. There's at fault and there's no fault. The at fault they talk about here, they itemize a whole bunch of reasons for at fault terminations. They're all different variations of breaches of contract: default in rent payment, breach of material term of the lease, committing a nuisance, committing waste, criminal activity, they're assigning or subletting. There's all these different reasons that people can be terminated from a lease. Legitimately, the ordinance does not prevent owners from terminating the lease for these reasons. Okay. However, we're going to go into item C here on page 7 at the bottom. No fault, just cause. So these are the reasons that you have as a landlord to terminate a lease, even if the tenant is not doing anything wrong. So if you intend to occupy the property by yourself or a family member, and remember we talked about the definition of family member, then you can terminate the lease. If you have to comply with the government or court order, if the government's going to say, hey, we're going to take control of your building because we're going to put, a freeway through here, then obviously you will be able to terminate your leases. It's probably not a very common one. The two more common ones are going to be number 3, withdrawal from the rental market. It's terminated because based on the owner's decision to remove it from the rental market. And be careful, because if you put it back, there's going to be penalties involved, and we'll go over that in a little bit. And number 4, substantial remodel or complete demolition. So remember the definition of substantial remodel. You have to fit all 4 of those criteria, or you're going to completely demolish the building. You know, sometimes people will tear down a 4-plex so that they can put up a, 12 unit or whatever. So that gives them the right to do that. Now, there are some provisions that you have to keep in mind. You have to notice the tenant. You have to give them notice of their rights. And I don't know why they put this in this part of the ordinance and not at the front, or at least with the exemption. But if the property is subject to the tenant protection ordinance, this verbiage needs to be included in the lease agreement. Any leases starting March 1. If the lease started prior to March 1, then they have to receive it as a notice separate. So either way, they have to know about it. Okay. Reporting requirements. So you're going to have to report to the tenants, and you're going to have to report to the city. And we're going to talk about that a little bit. So for a no fault just cause, it basically says you don't have to give any notices. However, if it's for a no fault, if it's for an at fault, go back. No fault termination. See, even I get these confused. So you have to notice the tenant, notify the tenant why you're terminating the lease. So section I here, the notice for basis of termination. One of those 4 reasons that we talked about before, either intent to occupy, compliance with government or court order, withdrawal from the rental market, or substantial remodel. So you have to tell them why you're terminating. You have to tell them that they have a right to relocation assistance, and that has to be provided to them either as a credit to their last 2 months and or as a check within 15 days of the deliverance of the notice to terminate. And we'll talk about that more in a second. And 3, notice of right to receive future offer. So if you're pulling it off the market, or you're going to do a complete demo, you have to give them a notice that says, hey, you have a right to come back with the first right of first refusal to reoccupy that unit at the new rate and at the new qualification standards. And if you want to exercise that, it itemizes in the ordinance the things that they have to do. So they have to notify the owner in writing within 30 days of the termination notice that such thing is, that they want to or potentially want to, and they have to keep all of their information updated with the owner. Now, as a landlord, you also have to notice the city. So you have to tell them, and there is a specific website or email address that you go to notify them. Going back to the relocation assistance required. And this is why sometimes exempting the property when it's able to be exempted is important. So a tenant is entitled to the greater of, so this isn't necessarily the rent that they're paying, but the greater of 2 months of rent or 2 months of the U.S. Department of Housing and Urban Development's small area fair market rents. It's a mouthful. The other thing to remember too is if there is somebody in the unit that is elderly or disabled, remember we talked about that, disabled or elderly is 62 or over, then it's not a 2-month relocation assistance, it's a 3-month relocation assistance. So if you have a unit that's substantially under market value, then you may be paying a substantial relocation assistance to them, which is why it's important to exempt the property if it is able to be exempted. Okay. So we're going to skip over to page 11. Just a couple things to remember on this. Item number 2, that this relocation allowance is in addition to any security deposit that's owed. Item 4, this protects landlords a little bit. If the tenant fails to vacate after the expiration of the notice, the amount of any relocation assistance, rent waiver, whatever, is recoverable by owner in damages as an action to recover possession. Fancy way of saying you can evict them and claim those as damages in the eviction case. If the unit or complex is offered for rent or lease within 2 years of the date of termination of tenancy, the owner shall first offer the unit for rent or lease to the tenant displaced. If you don't, item number 6, if you don't do that, you can be liable for up to 6 months of rent based on the HUD fair market values. So it does get very expensive, and you want to definitely stay within the bounds of the law on this. That is kind of the main thing. And then this will affect, stay in effect to January 1 of 2030. So that is it lines up with the timeline of the TPA, the Statewide Tenant Protection Act. So kind of just a quick recap. And then if you have questions, go ahead and shoot them in the Q&A section, and I will do my best to answer those. I don't see anything in the chat, so yeah, Q&A would be perfect. So the TPO, the Chula Vista Tenant Protection Ordinance, applies to, by default, all properties, but if you have a single family home or condo, it can be exempted. The TPO does not touch rent cap restrictions or rent cap requirements. If you have a multifamily unit and it's subject to the rent cap and the Tenant Protection Act, it is all the same still. And you want to make sure that you, like, I can't say it enough, you want to be able to make sure that you are exempting the property if it's able to be exempted. And if you have any questions about any of that, let me know. Some of the, if you have a duplex or a single family home with an ADU or junior ADU, there can be exemptions if the owner occupies one of the units. But that's, you know, that's kind of the gist of it. Let's see. So when I was sharing the screen, the max rent prices per zip code in an area, it's not the max rent prices. You can price your property whatever you want. There's not a, that doesn't reflect a rent cap. That is Housing and Urban Development saying that that is the quote unquote going rate for a property in that zip code with that number of bedrooms. What I'm afraid is going to happen, and we brought this up in the negotiations, was most rents that I see are not at those numbers. They're below or substantially below those numbers. And I'm concerned for tenants that when landlords look at that, they're going to say, well, why isn't my house renting for that much money? And truthfully, it's because it's probably not worth that much on the rental market, but that's what HUD is saying. And so the principle that they were going off was they were thinking, well, if somebody has to be displaced, they need to be able to find another place to rent, which makes sense. And so in order to find another place to rent, this is probably what they're going to be paying for that kind of unit in that zip code. So it is a little bit tenant friendly there in that case. So hopefully that clarifies that. And another question here. So if you have a property outside of Chula Vista, your home is not affected by this. However, the city of San Diego is meeting the mayor and city council in April to discuss their own version of an ordinance for the city of San Diego. I expect that other jurisdictions, including the county and possibly state, may come up with their own as well. And that could really create a lot of confusion if there's overlap of, you know, if the county has one and then the city has one and then the state has one, it can get challenging. So I'm sure attorneys will have a heyday with that. So if you have a property outside of Chula Vista, this may be a sneak peek of what you might be close to expect in the future. I don't know if they're going to change exemption standards in other jurisdictions, but that's something that we're keeping a very close eye on. Okay, another question here. Assuming you sent an updated lease agreement to current tenants. Let's see. So any properties that I manage have been properly notified. If you're pulling a lease agreement off of LegalZoom or Office Depot or Zillow, or even the standard real estate forms, car forms, it's not going to have the verbiage needed in those lease agreements to exempt the property from the Chula Vista TPO. Those those companies or those entities don't have that specific verbiage. So you want to make sure, especially if you know somebody who has been using one of those documents, make sure that they get the proper notice to the tenants. So let's see. Why do they want to all have their own laws now? Ideas, theories. Well, off the record, I'll talk to you off the record about that because I don't want to get too conspiracy theory-ish. But I will say that it is important that as citizens that we stand up for private property rights, because as that gets eroded, values get eroded, and the bulk of the wealth in the U.S. is in real estate, and so you don't want to hit that too much. Let's see, another quick question. I only own one rental home. The lease contract was signed October 2022. Do I need to amend the lease? That's a great question. So you don't need to amend the lease per se, but you do need to send a notice. It was required by March 1. So if you have not sent the notice yet, what I would recommend doing is I would send that to them and ask them to sign that they had received it. I don't know exactly how that would play out in a legal court setting. Hopefully you never have to terminate for no fault. But my recommendation, and again, this is not legal advice, but my recommendation would be to go ahead and send them the notice, and you can pull the notice off of the chulavistaca.gov website. You can send them the notice and just ask them to confirm that they have it received. And that should, knock on wood, protect you. Any other questions deeper on that, I would recommend contacting an attorney just to confirm, but that would be my understanding. Okay. So there we go. Any other questions? And I'm sorry it muted there for a little bit while I was screen sharing. I've never had it do that before, but in property management, we always have something new every week. So that's my new thing for the week. Any new language that we should add to our leases to better protect ourselves from the TPO? Only what they have provided. So that verbiage, that document that says that the property is exempted, that's what we put on all the lease agreements now moving forward, and that will protect owners for properties that are able to be exempted. And I didn't go into all of the potential penalties for things, but it can get steep, it can get severe. The city has come out and said that their intention is to work with landlords and tenants in a way to facilitate cooperation and not turn it into a litigatory nightmare. But it is tough because a lot of landlords aren't even aware that this went out. There was a lot of notification to multifamily properties, but I don't know that there was a lot of notification by the city to single family rental owners, at least not anybody that I've talked to. They choose when and how to enforce. Yeah, it will be enforced most likely as tenants complain or file notices with the city or file complaints with the city about people that may be not following this. And, you know, we're already starting to see some, I just talked to somebody yesterday who had their landlord submit a notice to terminate. The property should have been exempted, but was not. And so now, you know, they're going to have to talk to probably an attorney and see what makes sense for them in that situation. So it's not necessarily arbitrary, but it will be enforced most likely as complaints are received by the city. And those are received and processed through, I believe, the city attorney and the city attorney's office. All right. And you are very welcome. All right. So if you have any other questions, feel free to reach out to me directly. My phone number is 619-370-6555. And I look forward to hopefully doing this again soon. I'm looking at other potential webinars on similar topics like the Tenant Protection Act, the statewide, fair housing, which is another big one. If you're a landlord, you do not want to be in violation of fair housing law, and it keeps expanding. So you got to be careful. So thank you everybody for coming out. I appreciate it. Thanks for working through this with me. And I look forward to talking to you all again in the near future. Have a wonderful day.